Yeah, it's a show. But,
You're a tourist. You have your twin brothers.
But actually, it's quite hard to get some. Yeah, I mean, I've seen it because maybe
when I was at university,
It's interesting that for 2020 you might have to be 100%. Yeah, for the last 3 years.
I think that's super. I mean, I like to.
We went to it's probably with one of the
Yeah, I'm just going to say, particularly this next slide.
No,
I think we should lean into the title.
You explained in London. We're gonna do this. We're gonna do this. Where did the body hold? I mean, one of the benefits is you become they've got stuff like this. So they don't sell them.
It's a lot of red tape with UK firms.
Yeah, and so you will get to market going, this is fantastic. So you've got to start up. Get all of the various stakeholders. That's great. Is there anyone else? You can have a lot of money. Thanks, okay. When you start healing the brain, way to go. Yeah, I mean, when it comes to renewal negotiations, it's very, that's generally
yeah, they're much quicker in terms of decision making.
Alex, I think we should ask people to start sitting down. Thanks.
Yeah, I'll do that to be honest.
It's a very nice way of saying people do this. Please do.
I heard from my wife, never told me to do anything. Would it be a good idea?
Yeah.
If you drank your mother. If you're not for one, my mother's in South Africa, so she spends just a month every year. So I don't have to assure my in-laws for more than 24 hours, which you get very full month. So at the moment, I'm getting a lot of apparently selling. I think your mother-in-law to some of her friends as well. She's in
I think you'll enjoy 3 days in Italy at Wales.
I woke up this morning and I went to school. So what's first thing? Which gets me to job. Yeah. Right.
I love it because it goes. How when you tell me that
right, are we good, Alex? Good morning, everybody. Thank you very much for joining us. I'm Edward Bird. I'm the CEO of Solomonic. Just going to give a couple more people in the back, I think, coming in. Can you hear me at the back?
Not really.
Okay, I'm going to try and speak even louder. Thank you very much for coming along today. Before we start, just very quickly on housekeeping. I'm reliably informed there is no fire alarm practice this morning. So if you do hear the fire alarm, it will be an actual emergency. Please do follow the direction of the Britcourt staff and exit the building accordingly. Okay, thank you very much for coming along this morning for today's session. We're going to run for about 45 minutes through to about 10 a.m. There will be time at the end, whether you're joining us online or in the room for some questions. So we will give you an opportunity. What I'd like to do is just very quickly explain why we're here today. So Solomonic, as hopefully most of you know, is a litigation analytics data set. And we realized that our data set was incomplete without the addition of the Competition Appeal Tribunal. And we set about building data around that with support from the team at Linklaters. And as we built that data, we realized just what an impact the CAT is having on English litigation, whether you look at it financially, in legal terms, or indeed in reputational terms. It was a very significant impact. And it struck us that there was, to use the rather crass, according to my wife, analogy, a bit of a cat amongst the pigeons. So we thought it would be very interesting to get some experts in a room to actually explore the CAT and what we've seen, particularly related to collective actions, and to think about how that might play out into the future. I know I couldn't have wished for a better panel than the one I present to you today. So on my far right, Sarina Williams. Sarina is a partner in the litigation team at Linklaters. She's co-head of their competition litigation practice. She's advised defendants on some of the highest stakes cases in the UK, including the interchange, FX, ATMs, power cables and emissions. She's currently advising Visa and Sony, amongst others, in respect of collection actions in the CAT. She was recently named one of the lawyers' Hot 100. So definitely somebody to have on our panel. And she's also chair of the ICC's Global Competition Commission Task Force for Antitrust Damages Actions. On my left is Robert Donoghue, KC of Britcourt Chambers. So Robert has acted in pretty much any of the major competition and regulatory cases that you've heard of, I suspect, including disputes in CAT and in the High Court, appeals against CMA decisions. So CAT is the Competition Markets Authority appeal body, as well as follow-on damages claims. He's also active in some of the biggest major collective actions taking place, including Gormson and versus Meta, the Google ad tech case, Ennis v. Apple as well. And I'm sure he's slightly embarrassed by how amazing this is. He's recently been described by Chambers as head and shoulders above his contemporaries. He is a brilliant and outstanding advocate. Praise indeed. And then to my immediate right, Gus Sellitto, who is the founder and chairman of Byfield Reputation Council. So Gus is a PR industry leader, most particularly litigation PR. I think you, in fact, were the founding chair of the litigation or the legal PR arm of the industry association. Gus has advised litigation funders, in-house counsel, senior management teams, and global and national disputes, and has particular expertise in class action disputes as well. So that's our panel. What I thought we'd do is we'd start by having a look at some of the data. So Sarina, could you talk us through the data and tell us what you think it's actually showing in terms of developments in the competition landscape?
I can do my best. Can people hear me at the back? I'm not sure I quite have the projection that Edward has. Got me. Thank you. So if we go to the first chart, so this looks at the volume of competition damages cases that are in the CAT, which is there in green, the competition list in orange, and the commercial courts in yellow. I think it's fair to say that the figures for the CAT and the competition list are pretty comprehensive. Solomonic are nodding. I think the commercial court is a bit more manual to put together. So read it in that light. I also think that 2024, there's a little bit of a backlog in terms of the websites on the court. So that's perhaps not quite as up to date as the other years. But I think even aside from that, the data is showing a very clear trend of claim volumes increasing in the CAT and decreasing in the competition list and the commercial court. If you look at 2014 to 2017, the number of CAT claims are outnumbered by both the commercial court and the competition list. Then in 2018, 2019, you can see the balance start to tilt. And from 2020, the number of competition damages claims in the CAT start to significantly outweigh the claims outside the CAT. And Robert will talk a little bit about why that is in a moment. And that's even without taking account of all of the regulatory appeals that take place in the CAT, which we've deliberately excluded from this data to focus on damages claims. Some of you might be wondering what's happening in 2024 with a chunk of claims suddenly being brought in the competition list. That I can say on good authority is because a bunch of new interchange claims have been filed in the competition list, which is the usual modus operandi before they're transferred to the CAT to be part of the interchange umbrella proceedings. So I think that we can expect that in the coming weeks. And if we move on to our second chart, which looks at the claim volume in the CAT broken down by collective proceedings, which are in red, interchange claims, which are in yellow, trucks claims in blue, and then everything else in green. I think the fact that we thought it was useful to split out the interchange and the trucks claims data from everything else shows that the impact that those cases in particular have had on activity in the CAT. And we'll talk a little bit later about some of the techniques that the CAT has used to manage those cases. But the other clear trend that you can see, if you look at the red section of the chart, which is relating to collective actions, is the clear uptick over the years. So it's pretty slow from the introduction of the regime in 2015, very, very slow until you get to 2021. But of course, then emboldened by the lower bar to certification that was in the Merrick Supreme Court judgment in December 2020. We see the regime start to really take off from 2021 through to 2023. And like I say, I think 2024, the CAT website is a little bit, has a little bit of a backlog, but we know from the press that trend has continued into 2024 as well. If we move on to our next chart, so this is average reported claim values. So this is showing the average reported claim value of a collective proceeding in the CAT versus the average for claims in the competition list and the commercial court. So the kind of just over 3 billion for the CAT is the average of all collective actions before the CAT, recognising that some are in the double-digit billions, like Merrick's and the ad tech claims, and some are in the the mere hundreds of millions, like Qualcomm and Le Paturel. I think Solomonic, as it kind of says in the bottom right, say the data isn't perfect since, of course, it's taken from pleadings, so it kind of relies on those being updated. But again, I think that the overall message that comes out of it is very, very obvious. Which is that the claim values in the CAT collective actions are absolutely massive, and of course that is made possible by the opt-out class action regime, where you can have an entire market that is covered without having to have any actual claimants taking active part. Then the final chart that we wanted to show you this morning was the subject matter breakdown chart. So this shows the different subject matter areas that are covered by collective actions. Now, for the eagle-eyed among you, you might be wondering how those bars add up to the total number of collective actions in the CAT. They don't. Cases can have multiple subject matters, so there is some double counting. But again, the trend is very, very clear, I think, and really well illustrated on this slide from the data, with collective actions originally favouring the more traditional areas for competition damages claims that we saw in the commercial court and chancery historically. So sectors like banking and finance, industrials and logistics, but much more recently, a huge focus on tech and consumer product claims. And there's quite a lot of overlap between those two as well. That's all I was going to say.
Thank you very much. Robert, if I turn to you, from your perspective, what do you see as driving the growth in CAT claims as we've just seen in the data?
Okay, well, it's tempting to say it's the attractiveness of UK barristers. That's not true. I mean, look, there are a bunch of reasons. Just to pick up on a handful. I mean, first, as Sarina alluded to, I mean, without getting into management speak, I mean, the collective regime has been a paradigm shift in UK litigation. And you see from the data, it speaks for itself. So 50 times 3.22 billion is about 160 billion. So there are 160 billion of extant collective claims before the CAT. And I know selfishly and parenthetically, I suspect that is about £1 billion or more in terms of legal services fees. So this is a big deal for the UK economy in terms of service-based business. And I mean, just to then unpack what's under the bonnet of the 150 billion, you have a bunch of B2C consumer claims that would never have been brought but for the collective regime. And you have a lot of B2B claims whose individual value would never have justified individual proceedings. So essentially what you have is you've a glut of litigation that would not have taken place but for the collective regime. Now, my sort of back of a fag packet estimate is that I suspect about half of the CAT's workload is directly or indirectly occupied with all things collective. So this has been transformational for the CAT as well. So that's the first reason. The second reason is you've got a very unusual combination in London of the second biggest legal services market in the world and first or second largest financial market in the world. Now, these collective claims in particular, but it also applies to large B2B individual claims, they are funded by typically hedge funds. And then you have the insurance industry providing insurance cover for the other side's costs. So there's confluence of a well-established legal market and an active and assertive financial services market, I think, has combined in London to come up with what I think is a unique set of different skills. Now, what this means, I think, in practical terms for London is that sort of scale and scope of critical mass of lawyers, judges, finance, insurance, and personnel, it does create an entry and exit barrier for other jurisdictions. And scale and scope, I think, in this area in particular are very, very important. That's the second reason. The third reason is that there has been really an explosion of regulatory decision-making, both by traditional competition law regulators and by other public authorities who have some competition or regulatory powers. Now, Sarina, I think, alluded to interchange. I mean, interchange alone, I think, has probably generated 15 to 20% of the CAT's workload in the last 5, 6, 7 years. Then you think of all things big tech, that has led to a huge amount of both regulatory appeals and damages actions. So even looking at a small handful of recent public authority decision-making, that has given rise to an enormous amount of both regulatory appeals themselves and either follow-on or hybrid claims that piggyback or inspired by the regulatory intervention. Now, you add on to that, in the last year, we have the Digital Markets Act in Europe and the Digital Consumer Bill in the UK. This will grow and grow because you've ex-ante regulation bolted on to ex-post competition. So I think this will continue to mushroom. Then, of course, you've got Brexit. And what that has meant for the CMA is a massive increase in funding, much more staff, and I think, frankly, much more assertiveness on the part of the CMA to show that they are a leading global competition authority outside the EU. So that's the third point. The penultimate point is, this is all related, the subject matter of competition law has expanded beyond all recognition, I think, in the last 5 to 10 years. And it is very hard to think of any aspect of economic activity in this jurisdiction that is not in some way affected by competition law. And I think shrewd businesses and general counsel, they realize that competition litigation is an important way of doing business these issues get the attention of CEOs and general counsel in a way now that they would not have got 10 years ago. And it's a fundamental way of accessing a market or defending a market position. Now, the only substantive point I'll make, just to give you an example in terms of the subject matter expansion, the law on unfairness abuses was effectively a dead letter for many, many decades. In the last 5 years, in a way that surprised, I think, many, many people, myself included, both unfair pricing and unfair conditions have experienced a dramatic resurgence. And you see this in the CAT. You got the Gormson case, Boundary Fairs, the Ennis and Kent cases versus Apple, the Apple Batteries case. You have a whole series of cases that raise essentially unfairness type allegations. And that revitalization, I think, has had a dramatic uptick effect in terms of CAT's workload. The final point is that there has, I think, been what I would call a globalization of competition litigation. Now, this is a different point to the scale and scope point I made as my second point. And it's more about, I think, the fact the UK has disproportionately benefited from what I would regard as a significant emergence of global competition litigation. So you take things like FRAND, big tech litigation, FX, LIBOR. These are cases that are being litigated on a global scale. And the playbook typically of claimants and defendants is that they will be litigated in a small handful of countries to test the water. Now, for various reasons, both because of the scale and scope I mentioned, but I think also the Anglosphere, the UK typically is one of the 2 or 3 top jurisdictions for these global litigation events. And it's given rise to a very interesting shift in terms of personnel. If you're a US litigation firm, both class action and defendant, it would now, I think, be unthinkable not to have a London presence. What you see more and more in these cases, it's actually the same firms active in the US litigation and the UK litigation. And these are all parts of global settlements whereby claimants are trying to leverage a single global payment by having these common personnel on both sides of the Atlantic. And the UK, I think, has been a significant beneficiary of that for various reasons.
Thank you. I'm just picking up on your points there and the significant rise in volume and activity in the court. It's not, I don't think, how CAT imagined things playing out a few years ago. Sarina, if I ask you, how has the CAT managed that growth in claims that we've seen in the data?
I mean, honestly, I think with some difficulty. The tribunal has been very open about the fact that the quite sudden and huge increase in claims has posed a lot of challenges. From a practical perspective, lots of the people in this room will know that the CAT has only 2 courtrooms to work with. In February and March, for example, the tribunal had the Linklaters trial in one courtroom for, I think, about 8 weeks, and the interchange liability trial in the other courtroom for 7 weeks. And that meant that nothing else could really be done except for in non-sitting days in those 2 cases. It's also very difficult for the CAT to get lay and economist members as part of the tribunal. So I think most people will know that the tribunal sits as a 3-person panel. But of course, that means being able to dedicate, for example, quite long periods of time for a potential trial at the end of this, which, if you are still practicing in your chosen field alongside sitting in the CAT, really just isn't doable. The CAT is also facing increasingly complex multi-party litigation, often with parallel individual and collective actions, like in RoRo, or claims at different levels of the supply chain, with the interchange claims obviously being the paradigm example of that. And I think what the tribunal has done really well is experiment with different case management techniques to see what works in terms of making those claims workable. So, for example, in the trucks claims, it split the many thousands of individual claims into different waves, hoping that earlier waves would encourage settlement of later waves. And that so far appears to have worked pretty well. In the interchange proceedings, the CAT has adopted its, what was at the time, very new umbrella proceedings practice direction, which is where the CAT groups together different host cases that concern the same or similar issues or matters or share similar features. And it's consolidated all of the individual merchant claims that were in the CAT and the competition list. I mean, Alex, actually, if you look back at the cat claim volumes chart, you'll see this huge peak in 2022, and so yellow is interchange. And that is when the cat said that it was going to set up the umbrella proceedings order in the interchange claims. And at its request, the competition list transferred anything that was waiting in the competition list to the cat. So that's the kind of huge spike of claims there. Just last week, actually, the tribunal, again in interchange, used its powers to designate pass-on as a ubiquitous issue under the umbrella proceedings practice direction between the Merrick's proceedings and the individual merchant proceedings. So Merrick's will join a pass-on trial in interchange that's scheduled to start in November. I think there's something else that the CAT has really been focused on is setting much more I don't really like the word aggressive, but aggressive deadlines to make sure that proceedings are moving swiftly. It's increasingly directing that regular informal mini CMCs take place in large cases every 2 or 3 weeks, so that the tribunal has, or at least the chair of the relevant tribunal, has clear oversight of the progress being made. And that, I understand, is set to continue and to be encouraged to be adopted in more and more of these large cases. The CAT's often listing hearings without reference to availability of external lawyers or indeed parties themselves, in the cases of my clients, which you can see makes sense in cases where there are lots and lots of parties. So probably finding a time that works for the counsel team for every party is going to be very difficult. But it's also being done in cases where there's really just one person or PCR on the claimant side and one on the defendant side, which I think does risk significantly increasing costs, particularly for those proceedings. I think it's also quite dependent at the moment on the panel you get if you do that. I thought that the tribunal in the mobile operators case, which had a CMC a couple of weeks ago, actually took a very pragmatic approach at that CMC, making the certification hearing, which is now going to be March next year, a little bit later than the PCR would have wanted, but at a time when all of the parties' counsel teams are available, and also said that the defendants couldn't have kind of a certain issue split out in advance. So it would be then, but only if all of the issues were dealt with at that certification hearing. The CAT's also, I think, really trying to limit the decisions it has to make at the certification stage to big issue points. Is this really going to stop the claim going ahead? And again, at the certification stage, I think that it's really encouraging co-defendants in particular to work a lot more closely together to try and garner efficiencies and to minimise the number of documents that have to be considered at the certification hearing. So, for example, it's ordered a joint CPO response with then individual annexes if needed for defendant-specific points in both the water cases and the mobile operators cases, and has encouraged the defendants in those cases to think about whether a joint expert report would be appropriate. And that's the case even though the PCRs in those cases chose to issue separate proceedings against the various different defendants, so they're not even part of the same collective. The final point I would make is that it's probably worth saying that the tribunal is continuing to look at what it can do in terms of giving guidance to the industry. So we are expecting further practice directions, one around what the tribunal is terming work-life balance, which is going to say, kind of when the tribunal is going to be sitting. So I think, making clear that it does sit through August, but the expectation isn't going to be that there is a hearing in August, recognising that lots of people plan their holidays for then, and everybody in this room works incredibly hard. And also potentially one around funding to try and minimise the skirmishes that we're having at certification stage around, which funding documents should be disclosed, whether they should be redacted, etc. And the CAT's also indicated an intention to refresh its rules later this year and to produce something akin to the White Book, so it would provide some practical guidance alongside the rules.
Very interesting and very helpful. It's interesting you picked up on the increasingly complex litigation that's coming through the CAT. So, Robert, if I turn to you, what have you seen as the change in the kinds of cases being brought?
Well, I mean, it's very much a mixed bag. I mean, as you see from the last chart that was put up, I mean, if you extract interchange and trucks, that's in a given year, most of the volume of the CATs. I mean, they are two big beasts that have hoovered up a lot of resources, and of course the cat, I think, quite a lot of difficulty. So that's sort of one or two buckets. We're seeing, I think, quite a lot of what I would call big tech cases. So I think a majority of the recent CPOs are ones which are directly or indirectly inspired by regulatory decisions in the context of digital platforms, and I think that will absolutely continue to grow in a very dramatic way. There's a rump of cases which I touched on briefly in my first remarks, which, I mean, they really are quite novel. So you've got cases like boundary fares, which raise very interesting points about are there duties of transparency, are there basic duties of fairness, and you've got a whole series of cases like that one, Apple batteries, some of the Google and Apple litigation, where the question of fairness of a charging structure or minimum transparency levels vis-a-vis consumers are being litigated. And I think they will be very interesting to watch, because what these cases are about, they're essentially trying to do two things, in my view. One, they're effectively recycling consumer law claims as competition law claims. And secondly, I think they're really trying to make up for the lack of a collective regime, at least a properly functioning one, outside of competition. Also, these things are trying to be shoehorned into competition cases because there is a collective regime for competition law, whereas the representative action in CPR 19.6, I think, has been a bit of a mixed bag in terms of being able to bring multi-party litigation. So I think if that rump of cases gets traction, we'll see, there's a boundary fares trial, I think, this summer, and some others in the pipeline. I think if they get traction on any meaningful level, then you will see, I think, a real sort of pirate crew of cases emerging, where essentially any area of economic activity vis-a-vis consumers then becomes up for grabs. And I think this pending case against the water companies, I think, is maybe the high watermark of that. And I mean, it is a striking case where essentially a regulatory failure and what seem to be purely consumer law issues are being litigated through the prism of competition law. So I think they will be the most interesting to watch, because if the courts run with these novel theories, then I think all bets are off.
Can I just add one point to that, which is Robert mentioned earlier a kind of increase in regulatory activity, which has driven lots of these cases. But actually, I think that what's really interesting is to see the way that lots of firms now are not waiting for the infringement decision before they start to bring these cases in a way that you might have seen historically, where people were focusing on follow-on. So, you know, there might be regulatory activity that there might not, but actually firms just don't want to wait around for the decision anymore. You know, they want to bring the cases, they want to drive them forward, they want to be setting the agenda. And I think that makes lots of these cases incredibly interesting.
Yeah, I mean, I think that's very important. I mean, not only are they not waiting, but they're not even not waiting for a competition decision. I mean, often if you have a market study or simply an inquiry, even in Australia, that'll be sort of put into a claim form, and someone says, well, there's something in this. And they sort of jump the gun even earlier than you would think. Yeah. So that is absolutely, I mean, and it goes back to my point about globalization. I mean, essentially, any sensible agency anywhere in the world who's saying anything remotely intelligent about platforms, you will see that stuff replicated in claim forms as giving some of the basis for a collective proceeding, which is remarkable.
Actually, Gus, coming to you finally, and you've been waiting very patiently. So we've just been talking about the globalization of disputes, the arrival of these big, high-value tech cases that move to sort of consumer orientation, and many of them so acting on behalf of, you know, every Facebook user across the globe, or certainly across the UK. How is reputation management different in the CAT, and what techniques are you seeing parties use to manage that impact?
Well, as a PR, Edward, who advises both claimants and defendants, so class reps and the class bringing the claim and the law firm behind the claim and the funder behind the claim, and increasingly defendants, I always start from the headlines. You know, what are the headlines here, and what's going on inside and outside of the CAT is headline grabbing. You saw the Solomonic data on the numbers, the damages, and the average damages vis-a-vis other courts, and how much higher they are. So let's put the CAT amongst the headlines a little bit here and look at some of the numbers and why they are headline grabbing, because journalists love a big number. So MasterCard, 14, look, the last time I looked, 14 billion pounds claim involving 45 million consumers or users. PlayStation, for those gamers in the audience, 5 billion claim affecting 9 million PlayStation gamers. Google search, 7 billion pounds affecting 65 million users. That's headline grabbing, and any firm behind that claim will be pushing that as an immediate lever as you come up to certification. So that, from a defendant perspective, potentially front page news. This is outside of the debate that's going on about class action systems in the legal press, how the CAT's working, whether the system is working, how our European cousins are looking at the CAT very, very closely. This is front page news, some of it. And if you look at MasterCard versus Merrick's, then you can see the effect of some of these headlines. So as a starting point, Edward, to come back to your point, the CAT is big numbers. Big numbers equals big headlines, and that needs to be managed. And the reputational levers from a defendant and a claimant perspective need to be managed and pulled at key junctures. If we talk about the specific mechanics of the CAT, I won't get into too much detail, but there are the mechanism has PR aspects to it, which need to be thought very, very carefully when you're representing both claimants and defendants. So when we come to certification, authorization, so the claim is essentially the class rep acts as the voice for the group, for the class, and that can be into the many millions. So is that person the right person to be speaking as the champion, the consumer champion? And we're talking, Robert mentioned the word unfairness and fairness a lot of the time. So, and at its very heart, we're talking about collective redress here. So is that person the right person to be bringing the claim on behalf of the class as the class rep? And if you look at Walter Merrick's, for example, former financial ombudsman, very, very strong reputation, he is going to be seen amongst consumers as somebody who is very credible and trustworthy. And that's very, very important. Similarly, Justin Patrell, I haven't butchered his name too much, but former Ofcom, bringing the BT claim. So in that certification, the authorization of the class rep and the PR that goes around that is really important. And then you have the eligibility of the claim. In order for a claim to proceed on such a large class basis, it has to have some foundation around it. So again, when these claims are first launched up to certification, you see a lot of PR from the claimant groups, and defendants need to be aware of this. So those are some of the mechanics. And I think when we talk about the future of the CAT, I'd like to talk a bit about distribution and settlement, because I do think that the CAT and class actions in the UK and Europe are naturally going to be compared to the US system, and all the pluses and minuses that we have with the US system as well. We can come on to that about the reputation of the class action system more broadly, because it's important. But in terms of the mechanics of the CAT, you can see that it has its own particular mechanics which have PR aspects that need to be thought about very carefully. I want to talk a little bit about trust and apathy, because I think these are two really important words. Trust in the system, i.e., I am a consumer, I am now part of a claim that can go on for a long, long time, how do I know when I'm going to be communicated with, what the damages could be? That's really, really important as these claims go on. So I think from both a claimant perspective, and this is where the class rep is really important, building trust in you've suffered a harm, you should be part of this. We're talking about opt-out claims here, so you're automatically part of the claim. But the important thing is that the trust you have in the process is maintained throughout. From a defendant perspective, and this is where I do think defendants, we will start to see more of this. From a defendant perspective, ultimately, you are still talking to somebody who is, depending on the harm suffered, going to still use your product. I'm not going to stop using my Apple phone, which I have in front of me, to keep time, because there's a claim out there about my battery dying very, very quickly. And I have noticed it dying a lot more quickly, I must say. So I might be happy to be part of that claim, but it's not going to affect me longer term in my choice to use an Apple product. That might be different if I drove a Volkswagen car when the whole emission scandal broke. I might actually change my mind. But we are talking about coming back to Robert's point, fairness, and how significant is the harm in my mind as a consumer. And when I'm advising defendants, I would say that, and Sarina and I were having an interesting chat before we started, you have to be very, very careful how you communicate with the class as a defendant, but you can do broader communications as part of your good corporate communications about trust, about how you treat your consumers, about how important your consumers are to you. And these are the things that these companies are doing anyway. But I think as the regime becomes more intense, and we are seeing a lot more claims, you saw the Solomonic numbers, defendants will need to think about the collateral damage over time. I'm not going to stop buying my Apple phone, but over time, I'm going to start trusting you less. And that has to be thought about, because some of these claims, a MasterCard, how long has that been going on now? Is it 4 or 5 years? A long time. So defendants do need to think about the trust and the apathy. And coming back to the apathy point, I think there are figures that show, and our good friends at Portland, another PR company, do an annual report on class actions. And I think it was up to 60% of UK consumers would join a class action if they felt that a harm had been suffered. But I do think at the same time, apathy will start to kick in if that class isn't communicated with properly. And particularly, we've now had 2 cases, I think, where we've had damages, and the distribution of those damages is going to be really important in terms of how that's communicated. And I think that's where PR has an important part to play as well. I think in terms of coming back to your point, the class actions and why is it different than CAT, going back to Robert's point that the CAT wants to show itself as a tribunal on the world stage as being one of the leading in these types of claims for consumer redress. And certainly when I travel to Europe, where I'm looking at how they're bringing claims in Europe, that the CAT is seen as you know, top of the tree in terms of how these claims are being brought. So I think the reputation of the class action system, of consumer redress, of collective redress inside the CAT, opt-out claims, I think there's all to play for there. I do think, from my perspective of advising claimants and defendants, we have to ultimately think about the end user here, the consumer, and how defendants and claimants look at that over the course of what can be a very long and technical litigation. I think defendants have more work to do in terms of communicating with people who have been affected by these actions. So if you look at, I will, conscious of time, but on the way here this morning, I typed in MasterCard class action claim. The first 2 things that come up, the top one is actually an information page by MasterCard, where it puts out very clearly why it's defending this claim. I was very heartened to see that, because as a consumer, I want to see that Q&A as to why I'm part of this claim. What are you doing about it? Why do you think it's without merit? And directly underneath it was a MasterCard.claim something, which looked very similar to the MasterCard page. And it was from the law firm behind the claim. So really interesting to see how you see the PR being used. And in fact, when I looked at that a few months ago, or at least maybe a year ago, I couldn't see that MasterCard. It certainly wasn't in the top 3 or 4 search bars. It might have been down the page. So I do think defendants are becoming a little bit more aware. And again, I was talking to Sarina about this. She tells me that defendants don't like to come forward and be too public about these claims. And I can see why. And you have to be very, very aware of the mechanics of when and when you shouldn't say anything, like in any litigation. But I do think from a trust perspective, we will start to see more defendants starting to be a bit more vocal about why these claims are being brought and their defences to them.
Okay. Thank you. I think that's really interesting. And I think we've raised a number of points, whether it's the increasing sophistication on the reputation side and learning lessons as we go along. Very clearly, the complexity and the challenges the court's facing and the global nature of what we're seeing as well. All to tell a story of where we think the future's headed. So in the remaining 5 minutes, I just want to ask the panel, when you look to the horizon, what do you see as coming through over the course of the next few years? Robert, if I'll start with you.
Okay, just to handle quick fire things. I mean, as Gus alluded to, I think what happens in the settlement and distribution stage, I think for many people will be the proof of this pudding in terms of its eating. And so one of the tropes, of course, and there's some truth in this, in relation to US class actions as well, it's very good for lawyers and funders, but in terms of putting brass tacks in the pockets of the class members, it has not been an unqualified success. Now, part of me thinks, well, so what? I'd rather give money to somebody who's done nothing wrong than allow someone who's done something wrong to keep it. But I mean, what heartens me is 2 things. One, the Court of Appeal has said it on more than one occasion. Well, look, we've got to be creative when it comes to getting money into the pockets of the class. So they're aware of that in general. Now, in big tech in particular, or indeed in a digital world, it cannot be beyond the wit of these companies and their customers to come up with forms of compensation such as payment in kinds, vouchers, innovative ways of compensating consumers. And I mean, to my mind, a digital platform says, well, I couldn't possibly manage to get money to users in any way that is useful. That should be laughed out of court. So I think this distribution settlement is very important. A lot of eyebrows have been raised, I think, with some justification as to funders' returns. But there is, I think, quite a delicate point here, which is, to my mind, we have a pretty competitive market in funding. It's quite a delicate ecosystem. And I think for the courts to upend that in quite a dramatic way is quite a big deal. Now, the Packard judgment, I think, caused a lot of problems. It looks like the market has adjusted as you'd expect an efficient market to do. But I would be cautious in general about the courts steaming in to the funding side, because I suspect the market in general will take care of itself. Third point, I think we will see much more resolution of carriage disputes by way of settlement. I think the ad tech is a good roadmap for carriage settlement being a good thing. Fourth, I think it'll be very interesting to see what the appeal courts make in relation to of appeals following off these collective action trials. We've seen that they have no interest in carriage dispute appeals. They have less and less interest in certification dispute appeals. And I wonder to what extent in general they will be interested in satellite litigation by way of appeal arising from collective action trials. And finally, of course, we've had 2 sort of mini settlements, and I think there will be a lot of settlements finding their way through the CAT in the next 12 to 24 months. And again, that will give us a big insight in terms of, is the system working, and where is the balance of costs and benefits?
Thank you. We've only got a couple of minutes, and we do want to open it up to the audience. So Gus and then Sarina, just your thoughts on the future, how you see things changing or evolving.
Very briefly, there was an article last week, I think it was about a week ago in the Telegraph, saying class actions gold rush UK lawyers, and it was quite a negative piece about competition claims in the cap. It talked about, as Robert said, claims being shoehorned into the cap that shouldn't be in there. Lawyers' fees pre-trial being running into £1 billion. So I think from a reputation management perspective for the class action system in the UK, that has to be watched very carefully. Coming back to settlement, I read somewhere that in the US, 12% of damages get distributed. So that's a really low bar. And I think as we get more and more of these settlements, we have to be careful that the kind of the ethos that surrounds consumer redress doesn't get lost. I think funders play an absolutely crucial role in access to justice. These claims wouldn't happen without funders, but there is a debate going on about the regulation of funding to ensure that consumer redress is protected. So I'm really interested to see how the UK continues to maintain its first-class reputation in these kinds of damages claims that we're talking about.
I'll maybe pick up on the settlement theme, because I totally agree that that is going to be incredibly important over the next couple of years. I think one thing that has been quite striking so far is that, as Robert says, we've had two kind of mini settlements, but they've both been in quite specific cases. So the first, where it was a cartelist with a very, very tiny market share, 1.7%. And the second with one of the boundary fares defendants, but somebody who, was kind of a former group company who is no longer in the market. And I think what will be really interesting to see on the settlement front is how the CAT approaches settlement of these claims that, that Robert was talking about, that really attack the business model at the heart of these companies. So in the Apple and Google cases, will a damages payment even be enough for the CAT to sign off on a settlement of those sorts of cases if they've got concerns by then as to the business model that's operated? Again, on the settlement front, I thought that there was quite an interesting decision. I'm sorry, I forget the case, coming out of the Court of Appeal late last year, which said that the courts have the power to mandate that parties participate in some sort of alternative dispute resolution. And I think that it'll be really interesting to see if, the CAT and the other courts start to adopt that and actually, kind of push the parties into having discussions at various milestones in the proceedings to see if you can knock them on their heads earlier. The only other couple of points I'd make is that, kind of much closer to home in terms of, what we're actually going to get out of the CAT this year. So we will get our first trial judgment from Linklaters quite soon. We have, as Rob said earlier, the liability trial in rail fares that is starting in a couple of weeks. We're also waiting for the certification judgment in the CICC interchange cases. And that's one of those claims where the PCR was given kind of a second go at formulating their claims after being denied certification the first time round. So we might, and I obviously act for the defendant side in that case, but we might see, our first class action that is properly denied. Those cases also raise some interesting questions around, opt-in versus opt-out. So we'll see if the CAT's thinking around the relative suitability test has moved on at all since their first certification ruling. And then I guess finally, Robert mentioned earlier that there's been a real shoehorning into the competition regime of cases that might traditionally have been seen more as, consumer claims or environmental claims or, data privacy claims in the case of the Gorms and Meta case. And, I would expect that actually the question of whether there should be a more general class action regime will be coming back onto the menu with the new government following the election. That was initially mooted for introduction in the DMCC bill, but didn't garner the support of government at the time. And then obviously, the bill was kind of rushed through when Rishi Sunak made his announcement. But it did have significant support in the Houses, particularly the House of Lords. So I would be very surprised if we don't see that coming back on the agenda.
Thank you very much. So I think lots of cause for discussion and reflection. We've got a few minutes to take some questions from the audience. I'm going to start in the room. I'm not sure if there are any questions from the online attendees. We've got some questions there as well, but let's start in the room. I've got a hand at the back, and I apologize, we don't have microphones, so please do project your question as loudly as you can, and let us know who you'd like on the panel to start with in terms of answering.
Sure. So Robin Noble from Zero. I'm an economist. I had the pleasure of being involved in one of the settlements that Sarina referred to earlier. And it struck me through that process that there's a really important jurisprudential point about where the boundary is between the role of the cat to decide whether a settlement is a good deal for consumers and the role of the class representative to decide that. And of course, that then has knock-on effects for the way in which defendants might want to engage in the settlement in the first place, how you negotiate it, all of those kinds of things. It'd just be really useful to hear from the panel sort of what their views are on that. Because as you said, we are now potentially over the next years going to see a lot more of these.
Do you want to start?
Yeah, let me get the ball rolling. Look, there are a lot of moving parts, Robin. I mean, one sort of delicate point is, of course, the class representative represents the class, and the funders are not meant to interfere. But I suspect in the real world, particularly when you get to the heel of the hunt of settlement, those seals may be less hermetic than you would think. So I think that there's an issue there. There's then a sort of issue as to between the lawyers, the class representative, and the members of the class who were not in the room, as to whether with the goalpost being in sight for the legal and economic teams, and the PCR maybe being at that stage captured, whether they sort of get on some level railroaded into a settlement that might look different if more scrutiny were applied. And then, of course, I think, Robin, your real question is, well, if there are these sort of inefficiencies or, dare I say, biases, which are problematic in terms of the claimant side, to what extent does the cat then step in as gatekeeper and say, well, hang on a second? And then on the other side, of course, I mean, one of the dirty secrets is that undistributed damages go back to the defendants.
Can go back to them.
Can go back to the defendants. And so you may have this sort of quite strange inertia at the point of settlement. So I think that there's quite a lot there to unpack, to use a catism. And I think it needs a lot of careful thought. I think a lot of this is quite subtle, but it's very, very important. And I think it's only by grinding through these settlements we'll see these inflection points and how they play out.
Yeah, I mean, I totally agree with that. I think it was really interesting to see the different ways that the tribunal approached the two settlements that have taken place so far. So, they really didn't get into a merits analysis at all on the Ro-Ro settlement, didn't really care that much about what had been agreed, on the basis that, the party's independent counsel and the class representative's economics expert had all concluded that the settlement was reasonable. But I think that one of the reasons for that was because that settlement completely avoided the question that Gus was talking about earlier, which was the question of how the amount was actually going to be distributed in due course, whereas that was front and centre in the boundary fares settlement. And I think that, I'm not super close to it, but there was some potential conflict of interest between the class, the lawyers and the funder because of the way that the case was structured, which meant that the tribunal, felt the need to, I think rightly, scrutinise the proposal incredibly carefully. And as part of that, the tribunal imposed effectively changes on the mechanics and said that the settlement probably wouldn't have been approved without those changes. Now, I think my personal view is that the tribunal has a really important gatekeeper role to play in that situation. And I agree with Robert that actually, PCR perhaps isn't quite as independent as you'd hope that they'd be for the rest of the case by the time you get to that settlement hearing before the tribunal. But I think from a policy perspective, the tribunal also has to be very careful that these cases have to be able to settle. Otherwise, the regime just stops being so attractive, actually, for the claimant and funder community. So if it is too interventionist, then claims start to go to the Netherlands or Portugal or somewhere else that has an opt-out class action regime without that sort of scrutiny.
Thank you. Let's take one online question. I'm afraid we're going to have to stop after that because we're going to run out of time. Alex, do you have?
Yeah, I've got a question here from Gemma Feng online, where she's curious to know whether there are any regulations to limit how much the third-party funders could receive. She said she recalled the Post Office Horizon litigation where the funders representing the claimants, the majority of the damages awarded. She says, is this an issue that the courts are concerned with to ensure that claimants receive the benefits?
So the answer is no. There's no regulation as to what the funder can receive. The courts, I think, will be focused on it, but I think they recognise that, as Gus was saying earlier, this industry can't really operate without funding. I think it's quite instructive that in the boundary fares settlement, the calculations were that the class was going to get something like a third of what the funders and the lawyers were going to get as a result of the settlement, and the CAT was completely fine with that.
But I mean, look, the bottom line is that a settlement must be approved, or if it's disputed, it must also be signed off by the CAT. And at that stage, in principle, the CAT is entitled to say, well, sorry, that's too much. So the fact a fee is contracted in doesn't mean necessarily that the funder would get that fee. So I think there is an important safeguard. But look, it's a very delicate ecosystem. Again, I think if the market is reasonably efficient, I say we leave well alone. But it's an important issue, and some of this stuff is pretty eyebrow raising at first sight.
Thank you.
Okay. All right, ladies and gentlemen, I'm going to have to call a stop to it. But I wanted to say before I let everyone go to, first of all, to thank Brett Court for hosting us this morning in their lovely venue and for their fantastic food. If there is still refreshment at the back, please do take advantage of it. Most particularly also to thank Sarina Williams and the team at Linklaters for working with us on this session and for your excellent contribution. To thank Robert for your wise words. You definitely are an outstanding advocate for the court and for the law, and Gus for your insights on the reputational aspect of these cases. Thank you very much for your time this morning. If you have developed an appetite for intelligence and litigation analytics on the CAT, please do look out for more. We are going to be publishing more of this in the autumn. But thank you very much for your time, and enjoy the rest of International Disputes Week. We know the lobby is set a lot.